Welcome and thank you for joining Seyfarth's webinar, A Look Ahead, the Legal Landscape for Massachusetts Employers in 2021. All participants are in listen-only mode. You will be able to submit questions during the presentation using the Q&A feature located on the right side of your WebEx window. At the end of the program, if time permits, we will do our best to address your questions. If your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Patrick Bannon. Patrick, you may begin.
Thank you. Michael, John, and I are pleased to provide the 2021 look ahead for Massachusetts employers. As you can see from the agenda slide, we have a full agenda, so I'll just offer two brief introductory points. First, we did a similar presentation last year, and unfortunately for us, we didn't charge anything for it because we'd be still fielding the refund requests. Our preview last year turned out not to be very accurate. So point one is that we're predicting as well as we can. We can't always tell what actually does lie ahead. And two is, as you can tell from the size of the agenda, we have a lot of material to cover in 1 hour. We're not going to be able to go all the way to the bottom to fully explain all of these different areas. We're really trying to help people understand what should be on their radar and what are the topics they should be thinking about and maybe preparing for issues regarding in 2021. If anyone on the call is looking for more information, a more in-depth discussion of any of these areas, certainly contact us. In many cases, we have other materials that go more in-depth on a specific topic, and we'd be happy to share those. So I promised that I would be brief, and we do have a lot to cover, so I'll now turn it over to Michael Steinberg to cover the first issue on our agenda, wage and hour issues.
Thank you very much, Patrick. Thank you everyone for joining us, and I will jump right into it. As you can see, we're beginning with wage and hour issues that are particular, or that employers should pay particular attention to during the COVID-19 pandemic. Now, you may be thinking, we're looking ahead to 2021, COVID-19, that's a 2020 issue, right? Well, unfortunately, as many of us, probably all of us are aware, just from scanning the headlines, COVID-19 is going to continue to be a primary focus of businesses for the foreseeable future. The case levels, the hospitalizations and deaths are continuing to surge here in Massachusetts and across the country. And the governor has recently pulled back on some of the business reopening that had been taking place since the late spring. And we expect that those sorts of changes that will impact businesses, their ability to stay open, and the capacity at which they can remain open, we expect that that's going to continue to impact the demand for employment and labor. So turning to the next slide here, what are the wage and hour issues that we should be paying attention to when there's a need to reduce the work week to, unfortunately, what some employers are looking at as restrictions tighten is reducing hours of work, reducing work week. So when to the extent that an employee is non-exempt and paid on an hourly basis, reducing the number of hours of work for that employee is not going to present a significant issue. The pay is simply an hourly rate for hours worked. Fewer hours worked means less compensation. But where pitfalls can be encountered is where we're talking about exempt employees who are paid on an hourly basis. Now, it's sort of beyond the scope of this presentation to cover all of the different exemptions to the overtime requirements under state and federal law. That's sort of beyond the scope of this webinar, but three in particular that require a salary basis are administrative exempt employees, professional exempt employees, and also executive, administrative, and professional exempt employees. So in general, exempt employees must receive their full salary in any week in which they perform any work. And that cannot be subject to reductions because of variations in the quality or quantity of work. So how does an employer sort of compliant with state and federal wage and hour laws implement a reduction in compensation for an exempt employee? Well, the Department of Labor, Federal Department of Labor, has provided guidance on this and has indicated that prospectively, employers can, as a result of changes in as a result of business cycle impacts, can prospectively reduce the exempt employee's salary. But the change has to be bona fide. In other words, employers should be looking at their long-term business needs and determining that a particular employee, they're not needed to work the same schedule. They're not needed to work the same amount, and therefore a reduction in their salary is appropriate. Keep in mind, however, that the salary minimum salary to qualify for the administrative and professional and other exemptions is $684 a week, both under federal law and in Massachusetts. So those are important things to keep in mind with respect to exempt employees. Another sort of consequence of needing to reduce the workforce is that employees who are exempt may need to pitch in and perform the duties of non-exempt employees who perhaps aren't available any longer, who had to be, who are no longer employed. During the pandemic, the Department of Labor has issued guidance indicating that as a result of the public health emergency, exempt employees may be asked to temporarily perform some non-exempt duties that are required by the emergency without losing the exemption. Now, notice that I said temporarily. It's supposed to be temporary for the public health emergency. Of course, what constitutes temporary as this pandemic sort of drags on is an open question. And we should note that this is non-binding guidance from the Department of Labor. It has not been really tested in litigation, but it is useful and it provides employers with a good rule of thumb that, at least for the time being, those sorts of, there is some flexibility there in terms of the job duties that exempt employees are otherwise performing. Now you'll see here that to determine whether an employee is properly exempt, just a brief refresher, in Massachusetts and under federal law, you're looking at the employee's primary duty. This is viewed holistically. There's no magic number to this. Generally speaking, if the employee is performing, the exempt job functions for 50% or more of the time, then that will suffice. But it's not necessarily, it's not necessary. An employee could spend less than 50% of their time performing exempt job duties. For example, an administrative exempt employee who is in accounting, who's asked to perform some non-exempt functions. If their primary duty, which means their principal, their major duty, their most important duty, when viewed holistically in terms of the job as a whole, if that's their primary duty, then they're going to be exempt. But as I said, during the public health emergency, there is some flexibility here. If the need for that flexibility is the result of the COVID-19 pandemic. So another topic that comes up not infrequently with respect to in the wage and hour space is employer efforts to pay employees an additional amount for particularly hazardous or physically demanding labor. This is what's often referred to as hazard pay. There's no requirement under federal or Massachusetts law that a private employer provide hazard pay, but employers that are choosing to do so, particularly to boost morale and to reward employees who are those frontline workers and those essential workers during the pandemic, employers need to keep in mind that that hazard pay, if it's provided, needs to be included as part of the employee's regular rate of pay. Now, you'll see the words regular rate are bolded there. That is essentially the hourly equivalent that is taken by dividing total compensation for work performed in a work week divided by the number of hours worked in that work week. And that's used as a basis for calculating overtime pay. So it's very important to remember that hazard pay does need to be provided, need to be included in the regular rate of pay. So what if we want to avoid needing to do that regular rate calculation? Well, you'll see the second and third bullet points over here in the column under hazard pay. Talk about a couple of other ways to boost employees' compensation or reward them for hazardous work during this period. Consider the use of discretionary bonuses. Those do not need to be included in an employee's regular rate of pay. So now turning to the next slide, a couple of other points that I'll hit very briefly. Unfortunately, our time is short here. A lot of other wage and hour issues that arise as a result of the pandemic relate to the change to telework. Employees are increasingly working remotely, and this impacts a concept under federal and also Massachusetts labor law known as the continuous workday. The idea is that all of the time that an employee spends working, from whistle to whistle is the language that the regulations use. The first primary activity until the last primary activity of the workday, that generally has to be counted as working time. However, back in March, the federal government passed some coronavirus relief legislation, including the Families First Coronavirus Response Act, which, among other things, authorized the Department of Labor to issue temporary guidance, to basically issue a temporary rulemaking. And as part of that, the department took the position that the continuous workday concept should be made more flexible to allow employees to have less orthodox schedules during the workday. For example, an employee that needs to take time in the middle of the workday to help with the child's education when the child is at school remotely, those sorts of things. So because the employer is being encouraged to provide flexibility with respect to the continuous workday, keeping track of time actually worked is essential. You'll see here, consider having employees log their time using a timekeeping software. Consider having employees sort of reach a clear understanding in terms of what their sort of modified work schedule is generally going to be. Having that sort of open communication and establishing an understanding about the agreed upon schedule will ensure that the employers are able to keep track of hours worked during the pandemic for those employees who are teleworking. As a result of telework, a lot of employees are also relying on their home offices. They may be relying on equipment such as computers or mobile devices. And a lot of questions arise about, well, do we need to reimburse for business or work-related expenses? And how do we do that? So as you'll see here, the Massachusetts regulations do not require explicitly any reimbursement apart from travel-related expenses. But we note here that there is some case law that talks about the fact that under the Massachusetts Wage Act, which is the payment of wages statute, employers cannot shift the ordinary costs of doing business to employees. And so those cases really raise a question of whether, particularly when an employee is working indefinitely from home, whether claims could arise in the future related to failure to reimburse for things like cell phone data plans and other incidents of working remotely or not working at the work site. Because of that, it's going to be very important, but on a going forward basis, to reevaluate and do that on a consistent basis, policies and practices related to expense reimbursement, whether the employer should take the step of providing an electronic device to the employee, providing that laptop computer to make sure that those expense reimbursement claims could be avoided. And last but not least here, the new hygiene protocols that employers are following, understandably and appropriately, following the CDC and state and local health guidance, raise the question of what time is compensable. And there's a very simple answer here in Massachusetts. Time spent, for example, getting your temperature checked prior to entering a workplace, that's going to be compensable under Massachusetts law. There's a very clear regulation that says that working time is all time during which employees are required to be on the employer's premises on duty or at the prescribed work site or other location. So even though there may be some question under federal law, in Massachusetts, that is going to be compensable time. So bear that in mind as you're structuring and implementing all the necessary steps that have to be taken by employees before they enter the work site and when they're preparing to begin work. So turning to the next slide, that's a sort of high-level overview of wage and hour issues in the pandemic. Now we're going to turn to sort of discrimination-related questions, and particularly the question of accommodations to disabilities and religious beliefs, given the fact that we now have a vaccine. So if we can move to the next slide. We now know that there is a vaccination that's been approved. We also know that there's probably going to be another vaccination approved very soon. And as a result of that, the sort of number one question about vaccinations that employers have is, well, can we require employees to be vaccinated? How do we approach the question of ensuring that employees are vaccinated, if that's something that an employer is thinking about doing? So this slide provides just a general framework that flows from the Americans with Disabilities Act, and the EEOC has laid this out in its guidance as well. Medical examinations and disability-related inquiries. Medical examinations would be procedures, tests that are designed to get information about either a physical or mental impairment of an employee or health information of an employee. And disability-related inquiries, just as the name suggests, those are inquiries that are likely to elicit information about an employee's disability. Prior to an offer of employment under the ADA, those are generally prohibited. During the period between the beginning of employment, but after an offer of employment has been extended, there's more flexibility with respect to medical examinations and disability-related inquiries. Most importantly, though, for current employees, any medical examination or disability-related inquiry must be job-related and consistent with business necessity. And that's going to be very hard to show. It's generally going to require either a conclusion that the disability would prevent the employee from fulfilling the essential functions of the job, or that the disability poses a direct threat to the health and safety of others in the workplace. So turning to the next slide. That's the framework. And now that framework has been applied in pandemic guidance. You'll see here, we have pandemic guidance that's hot off the presses, which is very exciting and gives us something very new to talk about in this webinar. Beginning in March, the EEOC, in light of the pandemic, revisited its H1N1 influenza pandemic guidance. And there are some key takeaways here that many of you probably are already aware of, but it's important to reiterate. Employers may take employee temperatures. That would be a medical examination under the Americans with Disabilities Act and the Massachusetts Chapter 151B. But those are permissible in light of the pandemic. Employers also may inquire about whether employees are suffering COVID-19 symptoms. That sort of an inquiry is not a disability-related inquiry, or if it is, the pandemic, the exigency of the pandemic makes it a permissible inquiry. Employers may also require COVID-19 testing, but note, not antibody testing. The reason for that is the CDC has not indicated, has stated that antibody testing is not indicated to determine whether an employee is safe to return to the workplace. Employers may also ask about travel and exposure to COVID-19. In the new guidance, the EEOC addresses explicitly the question of whether or not employees can be vaccinated. And so I'll turn to the next slide here. This is the question everyone's been waiting for. There was some lack of clarity around whether a vaccination was a medical examination under the Americans with Disabilities Act, which would be subject to those strictures we just talked about. The answer that the EEOC made very clear in December, yesterday, December 16, 2020, is no. A vaccination would not itself be a medical examination under the ADA, and therefore, employers can require them generally. However, there are a bunch of howevers here. The first is that the CDC has recommended that certain pre-screening vaccination questions should be asked of folks who are potentially going to be administered a vaccination to determine whether it's safe for that person to receive the vaccination. So if an employer, a private employer, is, or any employer covered by state or federal anti-discrimination law, is going to be itself administering a COVID-19 vaccination, okay, is going to be undertaking its own vaccination program. It's probably not most employers in the modern age, but there are some employers that may decide to go that route. Then those pre-screening vaccination questions, those are going to be disability-related inquiries, and therefore they have to be job-related and consistent with business necessity. Also bear in mind that that would not apply for those vaccinations that are administered by third parties. So in most cases where the employer is simply imposing a mandate, but then is requiring its employees to go to their private, healthcare providers or whatever their healthcare provider may be, is requiring those employees to go to perhaps to go to a CVS. That if the employer is not contracting with or otherwise really controlling the entity that is administering the vaccination, then the ADA, the EEOC guidance tells us, does not apply to those pre-vaccine medical screening questions. So for most private employers, there is a lot of flexibility here in terms of administration of a COVID-19 vaccination and requiring it for employees as a condition of continuing employment. Employers may also, the guidance from yesterday tells us, require proof of receipt of the COVID-19 vaccination. However, and this is really important, an employer that wants to have a record of that proof of vaccination should make sure to inform employees that they ought not provide any medical data, any medical information as part of that proof. Also, just a general point here, any employer that receives employee medical information or data needs to keep that information confidential, needs to keep it in a separate file apart from the employee's general employment file. Where the terrain gets a little murkier is, what if an employee doesn't receive a vaccination and the employer wishes to inquire about the reason for that? Those questions need to be very carefully considered. It need to be very individualized to the particular employee, and should not be any more intrusive than they need to be, because those could be disability-related inquiries. The closer they get to eliciting information about a disability, the more likely they are to be considered disability-related inquiries, where under the ADA, there isn't carte blanche to ask those disability-related inquiries. So turning to the next slide. Very quickly, there are two statutes, primarily statutes, state and federal. There are protections in discrimination against on the basis of disability, and the protections against religious discrimination under state and federal law. Those sorts of concerns, sincere religious objections to taking a vaccination, and an inability to take a vaccination for because of a medical condition that would constitute disability. Those are two instances where, even if an employer decides to require vaccinations, there needs to be an individualized process, what the law calls an interactive dialogue, and at least a discussion about whether the employee can be accommodated. Now, as we know, a disability may raise an accommodation issue because employees might be allergic to a particular vaccination, or may have a condition that would subject them to particular adverse effects from the vaccination. In the religion context, there are any number of sincerely held religious beliefs that may bear on that. For example, religions that take a particular view of consuming pork may have objections to vaccinations to the extent they have particular animal gelatins, et cetera. So there are these sorts of accommodation scenarios will come up. Sort of to put a bow on this, there are certainly going to be instances where an accommodation is not reasonable, either because it would entail significant difficulty or expense. It would impose a risk to the public if an employee, for example, is interacting with members of the public, if an employee is a healthcare employee dealing with patients and others who are particularly vulnerable. Also, it may not be possible to accommodate an employee by exempting them from a vaccine mandate, because it may not be possible for them to telework. But those sorts of accommodations need to be considered, even if an employer has understandably determined, and the EEOC guidance confirms, that COVID-19 in the workplace, the threat of spread, poses a direct threat to the health and safety of others in the workplace. The employer should be asking, can the employee perform his or her job functions remotely? Is there additional personal protective equipment that we could provide to help mitigate the risk? Can we impose a modified work schedule? Those sorts of accommodations are still an important part of the conversation. They're still legally required. An employer cannot automatically terminate an employee simply because they cannot be provided an exemption from a vaccine mandate. There still needs to be an interactive process to determine if there's a potential accommodation. And with that, I believe I will turn it over to John.
Thank you, Michael. So next slide. Oh, sorry, that's slide after that. So I'll be covering reductions in force, furloughs, and layoffs. So as some employers prepare for 2021, especially in view of the uncertainty surrounding COVID-19, some organizations may be considering furloughs and layoffs as a method for controlling labor costs. Next slide. At the outset, it's important to understand the legal distinction between a furlough and a layoff and the obligations that come with them under the law. A furlough is typically either a temporary separation from employment, where the employee is given effectively unpaid time off, or subject to a reduced working schedule. Typically, furloughs are accompanied by some form of continuing employment relationship, such as continuing to pay health insurance benefits, disability insurance, retirement, or other benefits. By contrast, a layoff is legally more similar to a complete separation from employment. Employees subject to short or long-term layoffs, where they're laid off and potentially recalled back to employment, they typically do not continue their employment relationship. One question that's been raised about furloughs and layoffs is whether an employee is entitled to payout of accrued paid vacation time under Massachusetts law. Normally, when an employee is terminated under Massachusetts law, employers are required to provide payout of an employee's accrued paid vacation time at separation. The AG's office has taken the position that vacation pay and accrued vacation is effectively wages, and the failure to pay employees that accrued vacation time at termination constitutes a failure to pay wages. The question becomes a bit more complicated when an employee is subject to a furlough or a temporary layoff. In the context of furloughs and temporary layoffs, the employee is out of employment for a period, but the question becomes whether the employee really needs to be paid out that vacation time. Fortunately, the Massachusetts Attorney General has published some guidance on the topic. For the purpose of furloughs, the AG's office has taken the position that the answer is generally no. The employers do not have to pay out vacation time as a result of furloughing an employee, where the employer continues to pay for some form of employee benefits during the course of the employee's furlough. The AG's office has clarified, however, that if the employer becomes unable or unwilling to continue to pay those contributions towards employee benefits plans, then the date where the employer ceases to make those payments will become the effective date of discharge. By contrast, the AG's office has explained that when an employee is temporarily laid off or they're subject to recall after a period of time, the answer to the question of whether vacation time needs to be paid out is generally yes. The AG's office has noted that employers and employees may voluntarily agree to allow the employee to retain that accrued paid vacation time and not have it paid out immediately. But the AG's office has warned that while it won't take enforcement action in that kind of a situation, it doesn't control private litigation. So there is some risk that remains there. And finally, I wanted to quickly cover some unemployment considerations attendant to furloughs and layoffs. Employees who are subject to furloughs can be considered partially unemployed when their hours and earnings have been reduced by more than 1/3. At least that's what the AG's office has said in terms of guidance. Although the actual reduction that would qualify for an employee to receive unemployment benefits is calculated on a case-by-case basis. The AG's office has also reminded employers that employees cannot be forced to use earned sick time before applying for unemployment, and that the usual 1-week waiting period has been waived for applying for unemployment benefits. So turning to the next slide, and the topic of reductions in force or RIFs, one key consideration employers want to be aware of when conducting a RIF is the specter of warrant liability. Warrant is a federal statute that requires employers to provide employees with a certain amount of notice in the event of certain kinds of layoffs or plant closings. So federal warrant, for the purposes of federal warrant, it applies to employers with at least 100 full-time employees or the hours equivalent across all of its facilities and stores. So the size of the employer is going to matter here. For larger employers, many employment losses won't trigger warrant. The number of full-time employment losses so warrant sees the number of employment losses at a single site of employment over a rolling period. So if an employer has separate sites, they may not end up being aggregated for purposes of warrant liability or calculating warrant liability under either of the two-prong analysis. If sites are close together, there is some risk that they share team members. There is some risk that they could be aggregated for warrant liability purposes. So there's a two-prong analysis for mass layoffs and plant closings under warrant. For something to be considered a mass layoff, an employer must discharge at least 50 full-time employees at a single site of employment over a 30-day period. And those employment losses must equal 1/3 of the full-time workforce at that single site of employment. By contrast, a plant closing, which triggers warrant liability, is a layoff of 50 full-time employees, regardless of the percentage of the workforce, over a rolling 30-day period. And those employment losses are the result of the closure of an entire site, one or more departments, product lines, or functions. And one note, reductions in hours can also, in some cases, trigger warrant liability. So I also wanted to cover the notice requirements for warrant. If there is a layoff that is going to be subject to warrant or trigger a warrant triggering event, employers must provide 60 calendar days written notice to certain individuals, including the affected non-union members, union representatives, and certain governmental agencies and officials. So that's the obligation under warrant if you decide that you have a layoff that is triggering potential warrant liability. This becomes a little bit tricky when you're predicting the period of a layoff or furlough. If at the time of a layoff or furlough, an employer, based upon the best information reasonably available to him or her, and exercising commercially reasonable judgment, reasonably concludes that a layoff will not last at least 6 months, it won't have to provide warrant notice at that time. But since these are fact-intensive considerations, there's always some risk. If based on the circumstances reasonably unforeseeable at the time of the beginning of the layoff is extended beyond 6 months, the employer must give WARN notice as soon as possible and presumably invoke the unforeseeable business circumstances exception. Workforce reductions caused by sudden and dramatic losses of an employer's workforce due to COVID-19 could suffice to meet the unforeseeable business circumstances under WARN. But the force of that argument is going to vary based on how predictable the layoff or RIF is. Moving to the next slide. So I want to cover RIFs and the potential consideration for releases of claims and disparate impact really quickly. When implementing a RIF, an employer should be cautious and think through their approach. First and foremost, an employer needs to ensure that there's a well-documented business case for a RIF. It's always easier to defend a RIF or layoff decision when there's a well-documented case for why the organization needs to undertake a reduction in force. There's also a risk when implementing a RIF that employees could be disproportionately impacted on the basis of their characteristics, which could give rise to potential claims under state or federal law. These are typically discrimination claims, for example, on the basis of race or gender. Employers should consult with counsel before conducting RIFs in these circumstances to analyze whether their RIF could potentially disparately impact employees and give rise to one of those types of claims. Employers, of course, should also focus on selection based on specific, reasonably objective, forward-looking factors applied consistently. As with the business case previously discussed, it's important for employers to take employment action consistently with the goals of the RIFs and objective factors in mind. Employers should consider providing some measure of severance in order to obtain an enforceable release of claim. Those releases of claim can help cabin and minimize potential liability coming out of a RIF. In the same vein, you should be aware of OWBPA, the Older Workers Benefits Protection Act considerations. That imposes additional considerations for release of claims for employees who are ages 4 or older. So with that, I'd like to turn it back over to Michael to cover COVID-19 the next topic.
So sticking with as we've been saying, COVID-19 is going to continue to be a dominant theme of the year ahead. And we have started to see trends of litigation sort of growing out of COVID-19 issues in the workplace, and we think that those are going to continue. So we wanted to try, to the extent that we can, look into our crystal ball and forecast what sorts of trends we expect we might see, we have been seeing and might continue to see. That's what we're going to briefly discuss in this next segment. So looking at the next slide here, the first major category of what we're calling COVID-19 litigation relates to, unsurprisingly, the failure to provide a safe work environment. These have been, so far as we've seen them, primarily tort claims: negligent infliction of emotional distress, intentional and negligent misrepresentation. We do expect that most of these tort claims, at least to the extent that they're brought by employees against an employer, related to exposure to the coronavirus in the workplace, will be barred in Massachusetts by the exclusivity provision of the Workers' Compensation Statute. Massachusetts Workers' Compensation Statute is a very broad, very muscular exclusivity provision, and this effectively provides tort immunity for employers. Now, that does not only cover claims against the employer, it would also generally apply to claims against coworkers, to the extent that there's, for example, a claim that a coworker exposed another coworker negligently in the workplace. To the extent that the coworker was acting within the scope of his or her employment, which is also a very generally most employment conduct in the workplace is going to be within the scope of employment for purposes of the Workers' Compensation Statute. Not all, but certainly most. Then those claims are generally, we think, going to be subject to the Workers' Compensation bar. That has not stopped these claims from being brought. Clever attorneys will always try to plead around the workers' compensation statute. So the next major category that you'll see on the next slide of COVID-19 litigation trends that relates to discrimination claims. So these are primarily age and disability related claims. They can take a variety of different forms. Generally, they relate to either employers' decisions to exclude people from the workplace or terminate them, or in some cases, separations of employment that are the result of an employee becoming ill and the need to replace those employees during the period in which they may be hospitalized or convalescing from the COVID-19 illness. There are also stereotyping claims, the claims that an employer harbored, particular views about high-risk categories, employees who have disabilities that make them more vulnerable to contracting COVID-19, or older employees. The EEOC has provided very clear guidance that employers may not, for example, postpone a start date, withdraw a job offer, because of that employer's concern that the employee is in a high-risk category. That would be sort of on its face age or disability related discrimination. Likewise, one sort of high-risk category is pregnancy. Pregnant women are somewhat more vulnerable to the illness caused by the coronavirus. That pregnancy discrimination raises state and federal anti-discrimination claims. And lastly, we expect to see, and this dovetails a little bit with a section that Patrick is going to be covering at the end about equal pay claims, pay equity claims, both gender discrimination or gender disparities in pay, and also other pay discrepancies on the basis of protected characteristics such as race or a color, national origin, etc. Title VII claims. These can take a variety of different forms. They can take disparate impact cases, for example, where an employee challenges a particular employment practice on the basis that it disparately impacted, it disproportionately impacted employees on the basis of race or some other protected category. As employers continue to make changes in their workforce, regrettably, as a result of COVID-19, we expect those sorts of pay equity claims to potentially be in the mix of discrimination claims. Challenges to employers' decisions regarding who was retained, who was let go, and whether reductions in compensation, for example, were applied equally. So that sort of runs the gamut in terms of discrimination claims. You'll see on the next slide that there will be probably a significant amount of litigation related to protected leave and also retaliation or whistleblowing. So what form can these take? Well, there's a whole constellation of state and federal laws that provide paid and unpaid job protected leave as a result of the need to recover, to seek treatment or recover from an illness, a serious medical condition. That includes the federal FMLA. That also includes, at least for now, the Families First Coronavirus Response Act. Now note that does expire at the end of the year. There is a sort of reporting going on right now about the potential for new federal legislation in this area, but it's not at all clear that the paid leave protections of the FFCRA are necessarily going to be part of that. That at least that's very much an open question. Massachusetts sick leave law, and also the new Massachusetts paid family and medical leave statute, which is going to be the subject of discussion in just a few minutes. Another category of whistleblower or retaliation claims relates to wrongful termination. These may be claims under the federal OSHA statute, or Massachusetts is basically a federal OSHA jurisdiction, but employees who complain about conditions related to workplace safety under OSHA. Also, alleged retaliation for taking protected leave, whether it's protected sick leave under the Massachusetts sick leave law, whether it's protected sick leave under the Families First Coronavirus Response Act, whether it's retaliation under the Massachusetts Paid Family and Medical Leave Statute, which is the leave benefits are going to be going into effect. All of those types of claims. And lastly, there's a common law tort, which is recognized in Massachusetts, known as wrongful termination in violation of public policy. This is a claim that requires an employee to establish that they were terminated or otherwise subject to, what was an effective termination for complaining about for engaging in protected conduct that is protected by a clearly established source of public policy. So these claims with respect to COVID-19 will probably, and so far they have taken the form of employee complaints about failure to comply with CDC or state and local health guidance. And the notion that employers who don't take those steps, employees who complain about lapses in compliance with CDC guidance, that somehow is a sufficient source of public policy to such that an employee who complains about failure to adhere to that guidance should be protected from termination. Those claims, there's no court in Massachusetts has weighed in on that kind of a state wrongful termination in violation of public policy claim, whether CDC or other state and local either ordinances or guidance, health guidance for employers. There's no judicial statement yet about whether that is legally sufficient to establish a wrongful termination claim, but it's out there, and we expect that those claims are going to, we're going to see, we expect to see a lot of them, or certainly a number of them. So moving to the next slide, we also expect to see, and there's unfortunately just not enough time to cover all of this here, but wage and hour litigation, the issues that were raised earlier on in this presentation all could result in wage and hour litigation. We also note here, importantly, changes to any commission plans or commission payments or production-based, incentive-based compensation. To the extent that employers have made changes, have decided not to pay out commissions, or have decided not to pay out, production-based pay, or have made changes to those kinds of plans, we expect to see wage and hour litigation, state and federal, mostly state, related to those claims. And as John mentioned earlier, the question of when an employee was terminated is one that becomes a lot trickier in the age of COVID, and therefore claims for unpaid accrued vacation time on termination, we expect to see Wage Act claims of that nature going forward. So that, I think, it covers it at a high level in terms of the litigation trends that we expect to see. And now I'm going to turn it back over to John.
Thanks, Michael. So I'm going to be covering the last topic in the COVID-19 realm, which is sector-specific guidance in Massachusetts. Next slide, please. So as we're all aware by now, Massachusetts has been progressing through the phases of its reopening plan in 4 phases. Most recently, we've moved back from phase 3, step 2 to phase 3, step 1. And along with these different phases Massachusetts has been moving through, there's been sector-specific guidance provided for different industries. Next slide. So as I mentioned, most recently, we actually moved back a step in the reopening plan from phase 3, step 2 to phase 3, step 1, which resulted in the closure of some businesses. This is significant because it marks the first time that Massachusetts has actually moved back a step in its reopening plan. Under phase 3, step 2, Massachusetts businesses were permitted to open in certain circumstances depending on community infection rates, and that has been withdrawn. There's also been a reduction in maximum capacity for certain industries, and there are other sector-specific restrictions that have been applied through guidance that was updated in connection with the move back to step 1. And finally, recently, effective Monday, this past Monday, COVID-19 order number 57 also went into effect, which restricts certain types of gatherings. It brought the maximum gatherings for public events in Massachusetts, public outdoor events in Massachusetts from 100 people to 50, and requires that all gatherings disperse by 9:30 p.m. regardless of whether they're indoor or outdoor. There are some exceptions to these restrictions, however, which are noted in the order. Next slide. So one question that employers might have is that given the unpredictability of COVID-19 infection rates and how that's going to impact the way that the administration handles sector-specific guidance that affects businesses, employers might be wondering, what do we do if this guidance impacts business? So in order to be best prepared for 2021, we brainstormed and we have some suggestions on how employers could be ready to respond to sudden changes in COVID guidance. First and foremost, we think it's important to have a designated task force of people who are kind of thinking through the concrete steps that you can take in terms of preparing for sudden changes to COVID restrictions. Having a plan of action for responding to changes will hopefully make transitioning between phases easier. We also recommend staying in touch with your industry groups. By coordinating with other businesses in your industry, it's easier to make your voice heard in case of restrictions that most significantly impact your ability to do business. It may also be desirable to review and ensure that you have insurance coverage appropriate for COVID-related events to the extent you're concerned about that. We also recommend, of course, staying on top of the law and changes in the law. We understand that can be tricky because COVID regulations are changing regularly. Seyfarth has a COVID order tracker where we track changes in the law, and if that's helpful, you can feel free to reach out to one of us about that. We also suggest, reflecting on your COVID-19 response plan in terms of what you did in March, seeing what worked well and keeping that in mind when you move forward in the future to react to these sector-specific changes. And finally, we also suggest planning ahead for the impact of COVID-19 restrictions on your business long-term in terms of expanding or restricting your workforce or supply chain. Before we transition to the PFML section, I'm going to read the CLE code. The CLE code is SS, as in Seyfarth Shaw, 7443. That's SS, as in Seyfarth Shaw, 7443. So moving on to the next section, I'm going to try to briefly cover Massachusetts Paid Family and Medical Leave Act. Next slide. So as most of you are likely already aware, Paid Family and Medical Leave Act in Massachusetts goes into effect January 1, which provides a significant number of new paid leave entitlements. The types of leave available involve 20 weeks to care for your own serious health condition, 12 weeks of family leave for bonding or to attend to a family member's active or impending call to active duty, and 26 weeks to care for an injured service member. And then beginning on July 1, 2021, there will be an additional allotment of 12 weeks to care for a family member with a serious medical condition. In the aggregate, there are only a total number of 26 weeks that are of leave allowed in the aggregate in a benefit year. Next slide. So there are a lot of topics in terms of the use of leave. For intermittent leave, employees are eligible to take intermittent leave under the PFMLA. Examples of intermittent leave include leaving on an occasional basis to take care of medical appointments or take care of to take leave on several days spread out over the course of a period of months. Under the regulations, employers are required to provide intermittent leave consistent in increments consistent with the other policies the employer has for leave. The department, however, clarified that it won't pay out leave in increments under 15 minutes. So for concurrent, the benefits under the PFMLA are run concurrent with leave taken under other applicable state and federal laws, such as FMLA, Massachusetts parental leave, sick leave, vacation, compensatory time, etc. So generally speaking, any of these types of paid leaves taken for PFML reasons will run concurrently with state-provided PFML leave and therefore run the clock against the 12 weeks, 20 weeks, or combined 26 weeks. Moving on to the next slide, just because we're short on time. The regulations differentiate between a covered individual's use of employer-sponsored disability leave, such as STD or LTD, family or medical leave, and accrued paid leave, which is a separate bucket of leave, which is PTO, sick leave, vacation, personal or compensatory leave. In terms of things that are not accrued paid leave, there's some nuance as to how they can be used to supplement PFML to get an employee up to 100% of their wages. For SSDI, workers' comp, and that sort of thing, the state will automatically offset the benefits. There is the ability for employers to offset against LTD, STD, or other company-provided PFML policies. So I'm going to cover quickly some recent updates. There are no offsets available for deductions taken in the past several months there have been a number of updates to PFML guidance from the department. One area that we receive a lot of questions in is whether there can be deductions or offsets for leave taken in 2020 and 2021. The department has actually recently changed position on this. Under PFML regulations, the weekly benefit amounts an employer is allowed under PFML is reduced by any paid family leave that the employee takes in the prior 12 months. However, the department has decided not to apply that to leave taken in 2020 to PFML leave taken in 2021. So if somebody has taken like mass parental leave in 2020, in 2021, the employee will receive a full allotment of their paid family and medical leave, regardless of the parental leave that they've taken previously, and that won't be counted against their leave in that PFML bucket. I'm going to move on to the next topic just because we're running very short on time. Next slide. So preparing for paid family and medical leave in 2021 and looking ahead, a few things companies need to make sure that they do is first and foremost, make sure that their policies are up to date, their handbooks and policies reflect their organization's leave policies and that those leave policies are consistent with PFML. In addition, we've received questions about the impact of COVID on whether employees can take PFML. Beginning in January 2021, employees who contract COVID-19 and meet the definition of a serious health condition will be eligible for up to 20 weeks of medical leave. In July 2021, employees will be eligible to take care of members who have COVID-19 when it qualifies as a serious medical condition. So those are some considerations you need to be aware of in terms of employees who contract COVID. And lastly, it's just important to be sure that you're training managers that they're aware of PFML and that those managers directing employees to the appropriate HR professionals. And with that, I'm going to turn it over to Patrick Bannon to quickly cover our last section.
Thank you, John. 3 quick points. One is we have more information on all of these topics, and a lot of it is off the shelf. We can provide it for free. So don't hesitate to ask. There's a lot of material here. 2 is my sleeper prediction for 2021. COVID isn't the only thing that happened in 2020. I predict that equal pay or pay equity claims are going to hit, unfortunately, a lot of the businesses in Massachusetts. I think the statute in Massachusetts and the environment are conducive to these suits. All a plaintiff's lawyer has to do is show that 2 employees of different gender perform comparable work and aren't paid exactly the same. And if that happens, then the employer has to explain the pay difference using a very short list of factors. It is not easy to do. Plaintiff's lawyers who win can recover their attorney's fees, they can recover double damages, and they can bring class actions. These suits, we haven't seen tons of them, but the numbers are increasing. And I think the real reason why these suits are dangerous to employers is there's so much more attention being paid now, really since 2020, but continuing into 2021, around issues of equality and whether the system at an employer or in the larger sense is fair and equal. So I think you're going to see these suits in 2021. And then finally, if there's any of these topics, a lot of businesses have to change in a lot of ways in 2021 because of COVID and then COVID resuming, something new that comes as COVID starts to fade away, hopefully. So businesses that have hummed along compliantly for a long time will necessarily have their business model get tweaked in little ways. So I would just urge everyone on the call to stop and think when you make a change, whether it's about employee schedules or about how employees are paid or any aspect of your work. Just stop and think for a minute about whether it's compliant with the laws that we've run through. And, contact a lawyer, whether it's an in-house lawyer or someone here. We get these questions a lot from many employers. Most of them we've heard before. We can often provide at least triage. Is that a red? Is that a yellow? Is that a green? Very quickly. So it's not necessarily an expensive proposition, but there's a lot of changes ahead in 2021, and changes unfortunately make the world more difficult from an employment compliance standpoint. So thank you everyone for your attention today. I'm glad that we were able to win out over going outside to shovel snow. We have questions that are on text. We don't have time for them, but we will follow up with every question that we got during the call in the days ahead, and we'll answer those. So thank you again, and take care.